Sometimes sentencing can be mostly focused on deterring the defendant and not so much about deterring the rest of us. I find myself repeatedly saying sentencing is about deterring the defendant and deterring the community. To be fair, sometimes there are cases that don't really involve general deterrence. Hey, that doesn't stop general deterrence. That can still happen. Rather, the deterrence is more focused on that particular defendant. Here's a case where I think sentencing didn't involve a heap of general deterrence. It's from here at Maitland Local Court, and it happened in early September 2024. The defendant is a 25-year-old Aboriginal man who I will call Daniel. That's not his real name. Daniel is in custody in Long Bay, which is a jail in Sydney. Daniel's coming into the court via video. You can't really see the screen from the gallery at Maitland. At the start, Daniel's solicitor reminds the court that Daniel has another case being heard in Newcastle Local Court on that same day. It's a different solicitor doing that case, and for Daniel it doesn't matter very much because he just gets beamed into whatever courtroom he needs to when the case has been heard. I think the other case at Newcastle overshadows this case here. The court is told the other case involves 41 counts of drug supply, which are mostly a commercial quantity. That's quite a serious offence. From the way that they are talking, it sounds like Daniel has accepted he's about to do 5 to 7 years jail. So back to the case here that is about to be sentenced. The magistrate starts with, "This is tragic." As the sentencing unfolds, we hear details from something that happened when Daniel was a teenager, and it is horrific. At one stage, the solicitor doesn't even want to say what happened, but some of the details are said out loud. It involves suicide. The details are awful. So after this incident, Daniel leaves school and starts an apprenticeship as a chef, where he is introduced to drugs, which leads to what is described as a debilitating meth addiction. It's noted that his offending is not violent, rather this case involves fraud. Daniel has pleaded guilty to a micro-business fraud matter, meaning he has defrauded the government of $22,000, as well as a Facebook marketplace fraud of $800. There is also a drive under the influence of drugs charge. So when it comes to sentencing, first the drive under the influence comes with a disqualification, but I think that's a bit pointless because David won't be driving a car for the next 5 to 7 years. He is convicted of the Facebook marketplace fraud and given a community corrections order for 18 months. Again, he won't be in the community because he will be in jail during this period. The court does make an order for Daniel to compensate the person for the $800. Same as the micro-business fraud, he is convicted and given a community corrections order. However, the magistrate declines to make an order to repay the $22,000. It's my understanding it's unrealistic to expect a person in David's position to repay the debt. I take it to mean he won't be working a job in the next 5 to 7 years because he will be in jail. So this becomes a sentencing that's all about Daniel and his set of circumstances. The sentence is overshadowed by the more serious indictable offence at Newcastle Court, and therefore this sentence should not be taken as a general deterrence. Daniel's sentence here is not meant for us to look at and think, oh well, the next offender will be sentenced to something similar.